Can you hear me okay?
Can you hear us?
Now I can, yeah.
Yeah, we have you muted.
Is she the only one who's joined?
Yeah, I've
Okay,
not
good.
admitted anyone else yet.
Okay, good.
At least I put makeup on and everything.
Wow, me too. I know what it takes.
Okay, I think you could admit people. Give me 2 seconds.
Okay,
You look good.
And
thank you. I can't really see myself. Am I on?
No, you look good. You look super professional. She
Okay.
looks really good with glasses.
I'm going to admit everyone now, okay?
Okay.
Feel free to you're not a administrator, but you can write stuff in the chat.
Okay, and
Okay.
I'll tell people I'll read their chats and ask questions or whatever.
Okay, if it allows you to. I'm not sure. We're going to improvise. Brandon, can you tell me when I'm like halfway? Can you just say halfway? And can you say 15 like that? Right. Thank you.
you're live on Instagram right now.
Am I?
Yeah, you're
Oh.
broadcasting.
Perfect. Okay, we've got a bunch of people joining us. Love it. Perfect. It's almost happy hour. Hey, everybody. Feel free if you'd like to, we'd like to keep you muted if possible, but feel free to share your camera with us.
Yeah, we'd love to see your faces.
We want to make this as interactive as possible.
Okay, the
Let's
person
see.
that has iPhone, can you, is there a way that you could put a name to on your Zoom or just tell us what your name is?
Yeah, that's probably me.
Hi. Yeah, you can even throw it in the chat if you'd like.
There we go.
Yay!
Awesome. Oh, look at that. We know Tyler.
Yeah.
That's good to put a face with a voice.
Yeah.
Lo and behold, we know him. Well, it's good to see you on the call. It's great.
Yeah.
I know. I saw the signups, and we had quite a few clients or people who have inquired. So it's nice to be able to see those people and have them with us. So how many of you are here for the wine? Because you love wine. Okay. I guess Barbara says yes to that. How many of you are here to learn a little bit about wills? Perfect. Darren's on board. All right. And Tyler too. I love it. And we're going to talk a little bit about both, but we'll probably spend more time talking about wills than we will about wine. So welcome. This is our second Wine and Wills Wednesday. And we are going to try and keep this thing rolling because this is a fun way to get the word out about what happens when things go through probate, how to avoid probate, how to talk about the essentials of estate planning in a fun environment. We're going to make this interactive. So at the end of the call, we'll give you guys like 15 minutes or so to ask as many questions as you'd like, and we can offer live feedback too. So we're streaming this. We'll be sure to record it. We're hoping our audience will grow over time. And definitely share because, a lot of times, especially for parents, my parents included, believe it or not, they think they have everything in line. And sometimes there's one or two things that are just missing. And if we can share something like this with them and even a recording of this, if they can't be present live, it helps educate them on kind of what they need to do. And it's more of an icebreaker than if you just pounce on them at Thanksgiving. Hey, mom, dad, you didn't do this, right? They never like to hear that. So this is probably an easier way to approach them is by recording something like this and sharing it with them. So anybody, by the way, so let's start with cheers. Cheers to you. I do have my wine with me today. I'm going to have to invite the neighbors over later. Barbara, you guys, is part of our team here at Metropolitan Law Group. When you do your first call in to speak with someone, Barbara is the line of defense. No. We've got a great team of people here, and we want to work with the best clients. And so she is the first person we talk to. We make sure that, in fact, we're the right fit for you and you're the right fit for us. And so she's going to join us and hopefully offer some input too on this call. So cheers to all of you. So I'm going to tell you, this is kind of what we're going to cover today. I want to tell you a little bit about me, how I got involved in estate planning, the journey that took me this direction, why it's so important to me. Then we want to jump right into wills. So let's talk about what actually is a will, because for a lot of people, I think there is a misconception about what a will is and what a will isn't. And for others, there is sort of a misconception that a will and a trust are one and the same. And that's just not the case. No. So we're going to talk about how a will is different from a trust, what each of them will do for you. And then we're going to talk about who's a good candidate for a will. Because some people are an ideal fit for a will, while others are not at all the right. A will is not the right fit for them and will probably not help them meet their estate planning goals, right? So we're going to talk about that too. I'm going to actually have a taste of my first here. This is really good. And I'll share with you the wines that I'm drinking too. I have one client who is a huge wine connoisseur, and he signed up for this call. So I expected him to be on here and offer some more of an education around wine than I can certainly provide, but I don't see him on there yet. So hopefully he'll join us in a bit. So first of all, I'm going to tell you about these two wines that I'm going to be tasting today. Okay. As you can see, they look really different, right? So the first one that I'm tasting here, this is Oak Creek. It is and you're going to have to help me with this, Brandon, I don't know how you even pronounce this. All I know is it's a drier white. It comes out of Arizona. Some of you may not know this, but we have offices in both Minnesota and in Arizona. Hold on one second. Everything okay with the tech? You can't hear me?
Oh, there's a delay.
Okay.
We can't talk.
All right. Never mind. I can't get my tech guy involved because he can't. He's got headphones on. Okay. Anyway, back to this wine. I love this wine. So I have an office both in Arizona and an office in Minnesota. And I had a hard time because I'm in Arizona today from my kitchen. I had a hard time finding Minnesota wines out here. So my next trip is going to be to Minnesota, and I'm going to be sure to hit a couple of my favorite wineries there. And we'll introduce you to those next time too. So the Oak Creek is a vineyard out of Arizona that I visited about a month ago. And this is a really dry white that I really enjoy. I have a second wine with me today. It comes from Flying Leap Vineyards, and it is also out of Arizona. This is another one I tried. This one is really unusual because, you guys, it's actually a habanero chili infused wine. Has anybody ever tried anything like that? I've never had anything like it. But I thought, hey, you know what? We were eating tacos, so I thought habanero chili infused wine sounded good. I don't know that I'm going to feel the same way having it for happy hour on Wednesday, but we'll find out. So, as you can see, I've got these two wines. What do they have in common? Anybody?
They're both from Arizona.
They're both from Arizona, and they're both wines. Okay. What do they not have in common?
Different color.
They're totally a different color, right? They come from different grapes. They're not, one of them's spicy. The other one is not spicy, has no spice to it whatsoever, right? It has like honey and pear notes, it says. So they both are forms of wine, okay? But aside from being forms of wine that are both from Arizona, they have almost nothing in common, okay? The same is true about wills and trusts. Wills and trusts, the thing that they have in common is they are both an estate planning tool that is going to outline what your intentions are for your assets and your loved ones when you pass. That's the only thing they have in common. So like these two wines, they have one thing in common. They don't have much else in common. Okay. And we're going to talk about how they're so different here in a moment. I want to tell you just a little bit about me and how I started on my journey. Not so much with drinking wine, which I think came from being a Catholic girl and accepting mass. Right? That was my introduction to wine. Okay. But my introduction to estate planning was not something that I sought after. In fact, my background is in collections litigation. So I was a collections litigator. That means that my first job out of law school was, think of it as a glorified debt collector. So I represented banks and credit card companies. And those banks and credit card companies would hire me to take judgments against the debtors who failed to pay on those notes or those loans. Okay. So when they became delinquent, they'd hire me. I'd go to court. I'd take a judgment against them. And then I became really good at discovering assets. So figuring out ways to get my clients paid. And I did that through asset discovery searches. Sometimes I would go after someone's paycheck, if I knew they were gainfully employed. Sometimes I would attach a lien to their home. I could repossess a car, a boat, you name it, all kinds of fun things. But that's really what I specialized in. And other attorneys would come to me, they would take judgments, they'd win a personal injury suit, and they'd say, but now I don't know what assets to go after. I don't know how to get my client paid. Because if there's not liquid and there's not money sitting in a bank account, they don't know where to go. And so that's really where I came in. But I was spending every day in court and I was getting really, really burned out. And it was just becoming clear to me that this was not the path I wanted to be on anymore. I was a single chick living alone in Minneapolis, and I was making lots of enemies, suing people for a living full time. And I had, I had my car soaped. That was my personal favorite, when someone put a nice name, named me something across the window in soap of my car. But the real kicker was when I had a bailiff pull someone off of me in court while I was literally presenting an argument. And I just had this guy, just a crazy man, jump on top of me and had the bailiff pull the guy off of me. And I said, this is it. I'm not doing this anymore. So I was trying to, yeah.
You got no job satisfaction out of doing that, did you?
No job satisfaction. No, I got no satisfaction. That is for sure. No kidding. And in fact, Barbara, that day was the first of a few times that I asked the bailiff to escort me to my car, because I was certain that this dude was hanging out waiting for me in the parking lot. And that's just no way to practice law when you're a single chick, right? No, I don't think there are. You can come and take a look if you'd like. We got tech people helping me with this. This is the first time we've streamed over various different socials. So bear with us here at our first time. So I was like, what am I going to do with myself? I cannot continue down this path. I cannot continue going to court like this every day. It's too much. So, I was kind of lost, and I was struggling with what the next thing was for me, and not knowing where I would go next in my practice. I had some really sudden and really, really awful news occur. And I ended up losing my best friend and my brother just 4 months apart, unexpectedly. They were just 35 and 36 years old when they passed away. You can imagine, because they were so young, neither of them had done any sort of planning, certainly not any estate planning. My brother owned a home. My best friend, her family was out of state. And I was sort of forced to step up and become the person to represent the families and guide them through, the probate process during a time of grief. And I realized in doing that, as someone who spent her career in court every day, that the process is so difficult to navigate. Even as an expert, it is so difficult to navigate on your own. You need to hire an expert. And it just occurred to me that it's absolutely unfair and ridiculous that more people aren't aware of this. And it's very, very simple to circumvent all of this. We can prevent it all through proper estate planning. And so I made it my mission to transition away from credit, discovering assets, going after assets, and instead working with families to protect assets of their loved ones. Protect them not only from creditors, but from opportunists, and especially from probate court. And so my practice today is about working with families and setting up all of the right tools and taking the right steps to ensure that if something happens to them, their family can quickly gain access to any bank accounts, that assets will nicely transfer without a lot of court involvement, without a lot of delay, without outrageous court fees and attorney's fees. And then if somebody does find themselves in a situation where probate court is inevitable, we work with those people as well. So we help them to streamline things and get those assets transferred as quickly as possible, without sort of the delay and the added expense of litigation whenever that's possible. And so I always say, estate planning I did not choose estate planning chose me, right? And so I find what I do incredibly gratifying because I've been doing it for so long now that I have dealt with, second generations. And so I set up an estate plan. It was done effectively. I've been able to work with clients who then their children come to me and say, hey, my parents have passed. I want to let you know, but I also want to let you know everything was just so slick and easy and transferred. And thank you for making things so easy for us. And then now they're doing their estate planning with us. So it always feels good to know that you made a difference for a family. Absolutely. It feels a heck of a lot better than suing people professionally all day in and out, right? Cheers to that. Okay, I want to get into the nitty gritty of talking a little bit about wills, but first I'm going to try my habanero, my habanero chili infused wine. This ought to be interesting.
You'll have to let us know if it's spicy.
I know. Well, it has to be, right?
It has to be.
Okay.
Yeah, it's gonna be.
Oh, wow. It kind of bites you at the end.
Okay.
I might have to follow it up with the white. I mean, it's definitely interesting. I think it was better with tacos than it is just on its own at happy hour, but hey, wine is wine, in my opinion. Okay. All right, let's talk a little bit about wills. So many of you, or some of you may understand the differences between wills and trusts. Others may not. And there is such a misconception out there that wills and trusts are one of the same. And I blame the media. Okay, there's a lot of bad media. There's a lot of media telling people if Prince had written his will, there would have been no litigation. Everything would have smoothly transferred exactly where Prince wanted it to go. But Prince didn't write his will. Well, that is absolutely false. Prince had written a will, he would be in the same position his estate was, even though he didn't write a will. The reason is because a will, although it can be an estate planning tool, all right, just like these 2 bottles of wine are both bottles of wine from Arizona. One of the distinct differences between a will and a trust is that a will is a document that is prepared for a probate court judge. Okay. A trust is a privately held document that will never be seen by anyone other than the person who wrote the trust and their trustee, the person that they put in charge of managing their assets. It doesn't get recorded anywhere. It doesn't get filed with the court. A judge will never see it. So that is the difference, okay? Another significant difference is that a will is public information. You can actually see Prince's will if you dug a little bit on the internet, okay? It's public information in the state of Minnesota. You can do a search in, I want to say it's Carver County. I think that's where his estate was settled, and you can see his will. I've got a book coming out where I share Whitney Houston's will because she also did not have a trust and her will became public, so you can see that as well. So a will becomes public. What that means is that if assets are not transferred properly by naming a beneficiary on death, and you die with just a will, those assets have to be probated. They have to go through probate court, and that will has to be produced for a probate court judge. All right. Now, with the trust, the probate court judge never sees the document. It is privately held. And that means that there is no delays. The probate court is a very, very slow process. And I always tell people when they call us, they need to go through probate court. Many times it's because there is a frozen asset that they can't access. And Barbara, you know this very well because you take these calls from people, right? And people call her and they say, hey, my dad passed away and he had these bank accounts or he had a life insurance policy, but he didn't name anybody as his beneficiary on death. There was no payable on death for those accounts. So how do I get access to those accounts? He had a will. They'll say he had a will. And the reality is a will doesn't do anything as far as moving those assets, okay? Dad would have had to either name an individual who is alive and is an adult as his beneficiary on death, or dad would have had to have named a trust as his beneficiary on death, right? So when dad has just a will and there's no beneficiary on death, those bank accounts are frozen. And the banks by law cannot allow the next generation or next of kin and heir to access those accounts. They don't naturally transfer. So what the bank is required to do is to advise these people that want to access their dad's account that they need to go to probate court and get letters. Okay. These letters are a fancy word for a court order. The letters, and this is where people get kind of, they get a little confused because they'll call Barbara and they'll say, Barbara, they told me to just call a lawyer and get them to write a letter. Well, that's not what it is. It's not a letter from a lawyer saying this guy is this person's next of kin. It's a court order, right? So in order to obtain those letters, what has to be done is a probate action has to be commenced, meaning you have to file the will with the court and you have to nominate someone to act as the executor or the personal representative. Usually, if that person is appointed in the will, that is the person that the court will name to be the personal representative. Now, if they don't have a will at all, or if that person is unable to be the personal representative, the court will appoint someone else in their place. Okay. But this is a process, and this is a process that takes time. I would say on average in the state of Minnesota, in the state of Arizona, it's about 4 months on average to get that person appointed. And that is if everybody gets along. All right. And when I say everybody gets along, it means that anybody who's an interested party, that could be someone named in a will, either as a beneficiary or a personal representative, or it could be a creditor. Okay, so maybe before dad passed away, he was taken by ambulance and he spent a few days in the hospital. Well, now the hospital, if there's any outstanding payments due to the hospital for the services they provided or for the ambulance bill, those are going to become creditors of the estate. So they're then going to make a claim against the estate, meaning they want to be paid their portion. So now if you've got a will and you've got a probating of an estate, you've got your heirs, your next of kin who you intended to provide for in your will, you've got them going head to head with your creditors. All right. And so that can prolong things, that can delay things quite a bit. And if there's real estate involved, it nearly always takes about a year before we get everything cleared up, right? If it has to be litigated because the parties can't agree on who gets what, we can look at much, much longer. And 2 years is pretty common when there is a litigation aspect in a probate estate. And so you can imagine when you're paying a lawyer by the hour and they've got, a year of time in or more, and you've got, court expenses, fees, publication fees, sheriff's costs. We're talking about many thousands of dollars, and so people always, give me a little bit of pushback because trusts do, of course, they avoid probate court. So that is why they're so attractive, but they are much more expensive than just putting together a will. But when we get pushback from people about that, I always say, you know, the most expensive estate plan, and this is any lawyer will agree with me, the most expensive estate plan you can have is none at all. Because if you do nothing at all, your family and your assets are going to wind up in litigation against your creditors, or if they're fighting amongst themselves, and you're going to be paying attorney's fees and court costs and publication fees and sheriff's costs for a year or longer. And it's going to cost you at least 10 times as much as it did for you to just draft that trust in the first place, hire somebody to get that done for you. Right. So and you can seamlessly, how quickly, this is a question I get, how quickly can someone access their, their deceased loved one's account after they pass away when they have a trust? The answer is the moment that you receive a death certificate. So once you've got your hands on that death certificate, you can present that to the bank, and the bank will literally just transfer the funds over into an estate account that you can open. If you've got just a will in place, it doesn't work that way, right? We've got to get something from the court allowing that transfer to occur, and that can take substantially longer. So that is really the upside of creating a trust over a will. Yeah, Barbara, you want to weigh in?
Yeah, I want to stop you for a second because you've covered a lot of great things, and I do get a lot of clients that call, and I want you to address this because people don't know. They think, I've had several people call me and they'll say, but I have my sister's account number. Like I can go in, I have her online ID. And I ask them, I said, are you a signer on the account? No, but she gave me her ID. Like I can sign in and they're saying all these things with it.
It's fraud. Yeah, you can't. And that's a common question we get. Yeah. I mean, when someone's passed away, you can't start transacting on their behalf. Even if she gave you the verbal go ahead and access to her account, you've got her password, it's fraud. And what we're finding more and more is banks are catching on and they're flagging these. So even just the difference between 2 years ago, we had clients who, they would hire us to do probate and they would start transferring money from a deceased account because they had access to the account. That is not recommended ever. Okay. And in fact, that's going to have to be reported to the probate court when you commence that case. You're going to have to disclose that. You're going to have to provide a transaction, some kind of paper trail to show that happened, right? So that is a no, don't do that. You should not access someone who's passed bank account unless it was held in a trust. Okay. So don't ever do that. But the banks, as you know, Barbara, they're becoming more and more sophisticated, and it's like they're able to see. I don't know if technology has improved and they're just made aware earlier on that their client has passed away and so the accounts get frozen, or if there's some kind of a mechanism where they can follow an IP address when the transfer, I don't know what it is, but there's something that is flagging it as fraud. And so fewer and fewer clients now are able to actually do that. So that's not a solution, right? It's not a solution. And it's not. First of all, it's illegal. And secondly, even if you can do it, it's few and far between can get by with it now. Fewer and fewer clients. Yeah. So that is a good, thank you for mentioning that because yeah, you're right. You're right. So let's just talk about who is a good candidate for a will, because there are some clients who are a good candidate. Okay. Most clients are not good candidates, but some are, right? So when I'm evaluating a client, and Barbara, as you know, when people call the office, because there is this misconception that you write your will and everything is taken care of. Most people call and say, I need to write my will. They want to know how much does a will cost? And I can't just offer them a will because I don't know that it will necessarily meet their needs. So that's where Barbara comes in and she, goes through a line of questions during that initial 15-minute call. So she finds out what exactly your goals are. And then based on what your goals are, we can determine if a will is going to be a good fit for you or if there's something else we have to do. And in some cases, a will can be a good fit as long as we take additional steps to make sure that other assets are protected, right? And so we'll talk about some of those things as well. So what are the scenarios that put a person through the probate court process? So that's the first thing we're looking at. Anytime somebody has minor children, okay, by law, minor children cannot outright inherit. So if I name my 10-year-old son on my life insurance policy, my 10-year-old son, there's nothing preventing me from doing that, okay? My life insurance provider isn't going to tell me, Lisa, you can't do that. So I go ahead and I name my 10-year-old son. Well, what happens if I die? Okay. The problem is he's 10 years old and he can't by law just inherit a $500,000 life insurance policy, okay, payout. It has to go somewhere. Someone has to manage that. And the reality of it is it's usually the surviving parent who the court is going to appoint to manage that. Now, that might be perfectly fine for some of you, but I have a lot of clients who are not with the surviving parent. Maybe there was a divorce, okay? Maybe it's a child from a previous relationship. In which case you might not want your ex-partner or your ex-spouse managing your life insurance policy that is supposed to be used to be paid for your child, right? Your child's well-being and, college tuition. And if that's the case, that's probably not the best option. So, what do you do? What can be done? Well, you want to make sure that if you've got minor children, that you are not operating with just a will, okay? You want to make sure that you've got a trust in place, because if you have minor children and you pass away, minor children do have to go through the probate process. That's the first thing, okay? So if you have minor children, you're probably not a good candidate for a trust, right? Now, if you have real estate, you may or may not be a good candidate for a will. If you have one property and it is your residence, and you don't ever intend for that to have a second property. Let me give you an example. Let's say that I have just my condo, but I decide that I one day would like to purchase an investment property. Okay, then I am probably not a good candidate for a will, because I have more than just my one parcel of property that I reside in. If I decide I want to one day buy a cabin with my family with my brother that we want to keep in the family for generation to generation, not a good candidate for a will, okay? Now, if I am a person who owns my home and I only intend on owning my home, and I own that on my own, okay? It's okay if you have a lender who you're paying a mortgage to, that's okay. And I only have one beneficiary, maybe I only have one child, and I want my home when I die to go to my one child. I could totally be a good candidate, okay, for a will, as long as I put in place what's called a TOD, a transfer on death deed, okay? So for my clients who maybe they're single, maybe they own only their home and they just have one adult child who they want everything to go to, they could potentially be a good candidate for a will with a transfer on death deed. Another example of someone who would be a good candidate for a will is somebody who doesn't have minor children, but maybe they rent. Okay, I have a woman who is really successful. She's an executive at Target Corp. And she's got all kinds of investments. She has no children, all right? And she rents a really wonderful loft-style home in downtown Minneapolis. She doesn't have any real estate interests. She knows that when she passes away, she wants everything to go to her one nephew who's an adult. Okay, so now we've got one beneficiary. We're not creating a situation where we could potentially have heirs, fighting each other for it. She doesn't have any kids, right? She could be a good candidate for a will, along with the recording of a transfer on death deed, which will allow her real estate interest, if she has real estate interests, right, to pass outside of probate court. And we can handle that really easily by just having that person who takes control and assignment of the property once she passes provide an affidavit, and then the affidavit is going to allow that property to transfer into that person's name, the beneficiary's name. And we could do that without, having a big trust. But most people in reality are not that simple. And that's, another thing that people always call and they'll say, can you give me the pricing on a really basic or a really simple trust? My family's really simple. And the reality of it is, it might seem simple to you. You might seem pretty straightforward and simple. But if you have real estate interests, if you have minor children, if you've ever been divorced, if you've got creditors who could potentially creep up, you're not simple at all. And that's the reality of it. You want to take the extra precaution and put a trust in place and make sure you never create the opportunity for interested parties to go head to head with one another, right? Barbara, can you think of, does anything pop into your head? A particular situation we've had that we've encountered?
Yeah, I would love for you to talk about, so the transfer on death deed, because I have people that, when I find out their situation and we talk a little bit about the difference between a will and a trust, and they say, well, I can just get a transfer on death deed. Can you talk a little bit about the tax implications with a transfer on death deed if I was to get that property versus getting it from a trust?
Yeah, no, there are some huge implications, in fact. So I will start by saying, so a transfer on death deed will allow someone to inherit, and they can inherit potentially tax-free with a transfer on death deed, okay? Because, and this is where it gets a little sophisticated, so bear with me, but it's a non-taxable transfer at someone's death. Now, a transfer on death deed and quit claiming something through a trust is always more desirable than just quit claiming your house to your kid. We have people call and they'll say, hey, I'm just going to quit claim my house over to my kid. And my response is, please don't do that to your children. They do not deserve that. Because if you transfer while you're alive your home to your children, that is a huge taxable gain, potentially, right? Most property in Minnesota, I'm going to give you an example. Let's say I bought my house 20 years ago for $100,000. And by the time I die, my house is going to be worth $500,000. Okay, let's say I transfer 20 years into owning that home. I decide to quit claim it to my son. Okay, I quit claim the house to my son. I'm still living. Now my son just gained the difference between what I paid $100,000 20 years ago and what the house is worth now, $500,000. That's a $400,000 gain to him that I could have avoided by transferring through a trust or by doing a transfer on death deed and allowing that transfer to occur after I pass away. So quit claiming your interest in real estate while you're alive is not doing your kids any favor. And in fact, it's an awful idea for a lot of different reasons, but that's the biggest one, is that it's a huge taxable gain that they will have to report, right? So as far as why is a transferring through a trust more advantageous than a transfer on death deed? Well, there are several reasons. The first is, with a transfer on death deed, most of my clients are not transferring to one beneficiary, okay? Sometimes they're trying to transfer to 3 kids. That's probably the most common. I'm just going to, when I die, I want my house to go to my 3 adult kids. Okay, that might seem fine and dandy, but the way that it shakes out in reality, those are the telephone calls that Barbara gets, right? Because what happens is you've got a piece of property, and more often than not, it's like a family cabin or something, or it's a home, and you've got one or 2 kids who want to keep it in the family because they have childhood memories there. And then you've got a 3rd kid who doesn't live in Minnesota and hasn't visited the family cabin in years and has no interest in it and wants to sell it. So now you've got competing interests where you've got, now what do we do? And the kids start to litigate. And that's when we get the calls, because one of them wants to be bought out. He doesn't want the house. He wants to be bought out for his 1/3 interest in the value of the house. The other 2 want to keep it in the family. Okay, that's only one of many situations we see. Another that we see all the time is one of those kids is going through a divorce. And guess what? They just inherited 1/3 interest in mom's property. through a transfer on death deed. What does that mean? That means that there are no protections from divorce. That means that they could potentially now become a part owner with someone that their sibling is divorcing, an ex-spouse. Or worse off, the ex-spouse will get that 1/3 interest in that deceased parent's home in the divorce. And now you own 1/3 interest with someone who's no longer a part of your family. Okay, this goes so many different ways. Another thing I see that's not handled properly is, transfer on death deeds, and not just transfer on death deeds, but quitclaim deeds that are handled by non-attorneys. They get recorded improperly. And sometimes even married couples, and this even happens not just in Minnesota, but in Arizona, which is a community property state, it can happen where we will have two married people on a deed, and one of them does not automatically inherit from the other. And we see this all the time in Minnesota. And it is because when the deed was recorded, even though both people are named on the deed, there is no right of survivorship, because the title company or the realty company, whoever's creating the deed, did not fill out the deed in the best interest legally for that married couple. So the survivor does not automatically take all. So in those sort of cases, what happens is we get a call from the surviving spouse saying, "You've got to be kidding me. I've been married to this woman for 52 years, and you're telling me because she died and I'm on the title, I don't just automatically inherit?" And the answer is like, no, you don't. You have to go through probate court, and your wife's 1/2 interest is up for grabs. Okay, and that's going to take me to my third point about why having title transfer through a trust is so much more advantageous than through a deed. And that is because when I talk about creditors, I'm not just talking about credit card companies, mortgage. We run into tons of people, you guys, and Minnesotans, they don't believe in debt, right? Shame on you, you owe somebody money. I think it's a values thing, a cultural thing. We all want to pay our debts. I talk to people all the time who hire us and say, "Oh, we don't have any debts. Our mortgage is paid off." I'm always like, wow, that's amazing. We don't have any credit cards. We pay them off every month. So we don't have any creditors. We don't have to worry about that. Well, but what they're not thinking about is that creditors they don't always exist before someone dies. Okay. Sometimes they pop up after someone dies. And the most obvious example of that is what I talked about earlier, would be like a medical bill. So maybe they think we've got the greatest health insurance on earth. Okay. We've got fantastic benefits through work. We've worked at Target Corp for 50 years. My God. Okay. 30 years, whatever. We've got great benefits. So we're taken care of if we end up in long-term care, or if, we end up in a nursing home, or we end up on medical assistance, or we're in the hospital and we accrue, $100,000 in hospital charges. It's going to be fine. Okay. But the reality of it is, we see this because people's benefits do not always cover hospital stays. And a lot of it is out of pocket. And so that follows the estate. So when someone dies and there was maybe a fall, right? And grandma was taken by ambulance, and then she had to stay in the hospital for 3 weeks. Now we've got, $100,000 in medical bills, and we've got an ambulance bill. Grandma didn't have any creditors before she fell. Now grandma's got $150,000 in creditors' claims against her estate. And she's got this house, and she's going to transfer it to her grandson through a transfer on death deed. But guess what? We've got creditors' claims. And because the house is not held in trust, it's not held at all. It's just going to transfer at her death through a transfer on death deed. Now we have to file that with the probate court. And in doing that, one of the requirements that Minnesota and Arizona both require is that we serve the Commissioner of Human Services. The Commissioner of Human Services is who governs medical assistance and any of those sort of health claims that can be made against the estate. So we have to shoot out, sort of put them on notice, so to speak, that in fact, this person has passed away and there is a probate action filed and that they own a home, and it will allow, if there's any outstanding debts that have been unpaid, the ability to make a claim and put a lien on any property that exists. So now your grandson, who should have received your house when you died through the transfer on death deed, now he's got a lien for $150,000 against that house that needs to be paid because grandma's, house wasn't held in trust. It transferred through a transfer on death deed. So those are the types of things that, you think you've got everything covered, but the way that they shake out in reality is that there are things that come up in life. And so the real difference is here, we've got two things in common. They're both wines from Arizona, but aside from that, they have very little in common, okay? And I always tell people, if you want certainty, create a trust and transfer your assets to trust. You'll have certainty. You know what you're getting. If you're okay with the unknowns, create a will, maybe a transfer on death deed, and hope everything shakes out okay. But be prepared for uncertainty, because with a will, there is always uncertainty. With a trust, you nearly always know what you're getting, okay? And that's really what all this comes down to. All right, I gotta know, Tyler, do you have wine in your red Solo cup?
No, tequila.
Yeah. Oh my gosh. Okay. Well, we're going to expect you on our next one of these because, by the way, I'm not joking when I tell you we're going to do these quarterly. Our last one we did wine, and then we came across another attorney who's on, I think he's in Boston, and he did a Tequila and Trust Tuesday. And we're like, we're totally doing
Nice.
Tequila and Trust Tuesday. So our next one is going to be Tequila and Trust Tuesday. And that'll probably be like in when? June? That'll probably be in June. Yeah. And then we'll be expecting margaritas. So
That'll be a short meeting.
that'll be good.
Tyler, I had a feeling you had whiskey or something in there for like red.
No,
I
I'm
know.
trying to
Well,
drink healthier.
you and me both. I know. Well, I was thinking about it too. And it's, St. Patrick's Day is like right around the corner. We probably should have done Irish whiskey Wednesday. Irish whiskey and Will's Wednesday. That's what we should have done. But anyway, we'll remember that one for next year. We'll change it up. What was
Right.
Brandon, wasn't there another really good one? Oh, he's 5
You're not
minutes
supposed to
behind.
talk
He
to
can't.
him.
I know, I can't talk to him. He's our tech guy and he's like, I'm 5 minutes behind. I can't stop asking me questions. I'm like, okay. I guess it didn't work. Okay, you guys. Well, hey, we're kind of wrapping it up here. We're coming to the end. So please ask questions, chat a little bit. I don't know if I know how to do the chat. So I think what I'll do is I will, in case you guys actually are interested in these wines or someone who joins us on a future call, because this is being recorded, I will put this in the notes. And so you will be able to access these in case you make it out to AZ or in case someone on the call is in AZ and wants to try these wines out. I definitely recommend the habanero chili infused wine with tacos. It was much better than on its own. Or maybe it's just because it's only Wednesday and it should be Saturday before I get into the habanero. I don't know.
So Lisa, I am going to ask Tyler, Darren, or Karen, do you guys have any questions maybe that weren't covered in this call that you're like, that you want covered, that you are dying to know an answer to, since we have Lisa available she's available to us right now?
I just have a question about, I think I talked to you, Barb, about the checks that I received from my mom. It's written out to the estate of my mom.
Mm-hmm.
So I'm just trying to figure out, is that going to have to go through probate? Because I know I set up an EIN number through the IRS website, like you said.
Nice.
And I have the EIN number, but now I'm getting some stuff for benefits.
Mm-hmm.
And it's not written out to me solely because I don't know why she didn't have me down for that. But
Mm-hmm.
so I don't know if I'm going to have to do
Yeah,
probate
no.
now.
Yeah, no. So if it's written out, if the checks are written out to her estate, that means you can just deposit it in an estate bank account. So if you've already got your tax ID number for her estate, all you have to do is take that, to the bank along with the death certificate, and you can get an estate account open and deposit those right in there.
Okay.
So that's great. So that tells me that she probably named her estate as the beneficiary on death.
Okay. Okay. And then what else? What was my other question? If someone else has a question, it'll come back to me
Okay.
about that. Yeah. Crap. I just had a brain fart.
Yeah,
No worries. You'll
no
think of it
worries.
the second you get off the call, and then you can just call, you can text Barbara back. How about that?
Yeah.
I do have
Darren,
a
what's
couple.
your question?
Yeah,
Yeah, I got
Darren.
a couple little questions here. So, my first one is, we own our home here in Crystal in the Twin Cities. You know, the bank owns it, but
Mhm.
we're here 8 years. We own a home up in Silver Bay, just north of Duluth.
Love that area.
Oh yes,
So
absolutely.
pretty.
So we bought that outright 22 years ago. I want to protect that. That's a family legacy for me. And
Right.
a buddy and I, he is a nonprofit, and he bought the property. We bought it together, and he did a quit claim deed to get my name as co-owner on the property. Should I take a look at whatever was filed for that to make
Yeah.
sure I'm covered?
Yeah.
Okay, I can do that. And then,
Yeah, I mean, what probably would make the most sense is, and I don't have all the facts again, right? I'm just briefly, but you
Sure.
might want to look into considering creating an LLC, right? And then your LLC could potentially own that property, and the two of you could be members of the LLC together.
Right.
And I don't know enough about the nonprofit side of it, how much of it, the interest of the nonprofit, but that's something else you'd want to look at. But I would just say, just quit claiming it to you outright is probably not the best solution.
Yeah, I didn't think so at the time, but now that I'm 65 and still alive,
Well, dang, you don't look 65. Oh, you just a bad thumb, that's all.
oh, let's just say the table saw one.
Oh. No.
So
Oh
now I
no.
hear, so I have an old car that's worth some value and
Mhm.
a few other toys. You know, I'm 65.
Mhm.
You gather a few things with age. Um, how do I protect that car? I mean, obviously, I'm going to do a trust because I have multiple properties, a few
Yeah.
other like that. We're a blended family of 5 kids.
Oh yeah, blended families. You definitely need a trust.
Yeah.
Pay attention to that. But if I transfer my car into my son's name, for instance, and
Mhm.
what is the timing? If let's say I die in a year, will our government somehow go figure out that I transferred the title from Darren Arnold to Nicholas Arnold a year ago and then tax that or take that or whatever?
So I don't know exactly what the timing is, but yes, that would be a taxable transfer if it's income of over, I think it's $600 to your son. So the way that we recommend doing transfers with vehicles and sort of, we'll call them like tangible assets that are probatable because they're of
Yeah,
significant value, right?
right.
So what we recommend doing is when you create your trust, you would go to the DMV, and you would transfer title out of your name and then into the trust. So your trust would actually own those vehicles. And
Yeah,
what's nice about that is you can constantly be updating your trust and you can outline in your trust where you want, where you want it to go. So potentially your son, like you could give him access to the car and allow him to drive it, but you would own it. Your trust would own it while you're alive, right? And then you could direct that once you pass, it will be in trust transferred to him at your death.
right.
Now, if you do nothing, which we have a lot of clients who, they forget about their vehicles. So we're constantly reminding them like, hey, don't forget about this because those are calls Barbara gets too, where somebody will have, oh, my husband had an F-150. It's worth, $26,000. It's a beautiful truck. But he owned it free and clear, but it was in his name only. And now he died. Can I sell it? No, you can't sell it because you don't own it. You
Right.
don't, it's not registered to you. You don't have title. And so unfortunately that is probatable. So we get hired to
Right.
go through probate court for one vehicle. It's just like, oh, so frustrating. And what they should have done is they should have created a trust, gone down to the DMV, transferred title of the vehicle into the trust, and then you can easily, boom, you can sell it the day that you pass, right? If he wants to sell it.
Right.
Or if you want it to go to him, it'll transfer to him the day that you pass.
If I transfer a title into his name today and in 12 years I pass, will they still kind of come back for it? You don't know the timing, you said.
I don't know the time. And also, like, there are some gifts that you can give during your lifetime that are not taxable. And so, depending on the value and how much you've previously given, it might fall within that range where he won't get taxed, even if you do so. There's a lot of variables that come into play there.
Okay.
And so that's like,
if it is
yes,
a trust, then it won't get taxed.
no. And so
Okay.
that's, yeah. So
Then-
that's the beauty
I
of
don't know if
that.
you can see what's underneath my butt.
No, hold on. Hold on. What is it? It's a man's feet. And is he sitting in a fire?
Yes.
I can't, is it signed and autographed? What is that?
No, that's me in one of my old cars sitting on a log on the fire.
Yeah, that looks like you're sitting on a log.
Move it down a little bit so we can see the car.
Oh yeah, that was one of my other Chevelles I've had.
Oh my God, that's cool. Oh,
Yeah.
so you've got some old cars that are of value.
Yeah, I got another
Yeah.
72 Chevelle. It's a race car.
Nice. Yeah, I can see where you'd want to keep that in the family.
Oh, absolutely, yes. So
Yeah, that's probably the best way to do that because that would certainly be a probatable asset.
yeah. Oh yeah, they would be bad. So Tyler, did you think of your question?
Yeah, I did actually. I was just wondering because I spoke to a financial advisor. I guess like family, they own a financial advisor company in Eden Prairie,
Okay.
and he said today that I'd need like something like legally that states that I'm the beneficiary to open up the estate account because he said he could do it for me, but I don't. He said he didn't think the EIN was enough.
Did you go to the actual bank itself? Did you
No,
go to the
that's
bank
all.
and try? Yeah, you
No.
should be able to just bring the death certificate and the EIN, and you should be able to open an estate bank account.
Okay, cool.
Hey,
I'll
Tyler,
try that tomorrow.
I do have a question for you that's completely off topic. Is that a Christmas tree in your background?
Yeah, so I've been looking for the bag. I've been looking for the bag. It's a mess here right now, so I got a lot of cleaning to do. I got to get it
You're in
dumpster.
your mom's house, right?
Yeah,
Okay.
Well, good.
yeah,
It's Christmas in March.
yeah,
Yeah.
right.
Yeah. I mean, you could just leave it up until July, celebrate
Yeah.
Christmas in
Yeah.
July. And then when we have our margaritas, our tequila Tuesday, we can toast Christmas in July.
Yeah, right.
I love it. Awesome.
So yeah,
All
I'll
right,
just
you guys. If we don't have any other questions, we'll wrap it up and cheers.
cheers.
All right, I'm going back to the habanero. Cheers. Hey, thanks for spending time with me, you guys. That's really good, educated questions. Appreciate you.
All right, you
Yeah,
guys have a good night.
Thanks so much.
See
You
guys
too.
in June. Join
Yes.
us in June.
All
And
right.
and spread the word. Bye,
Bye-bye.
guys.
Bye. Okay, live video ended, I see.
Okay.